So perhaps we'll start, and then people can join us, of course. I'm Mary Troscliffe, Clea's Executive Director, and it's my pleasure to welcome you to the last session of our 2023 Law Conference. Today's presentation is on changes in family law. First, I'd like to acknowledge that CLIA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and dedicate ourselves to move forward in the spirit of reconciliation. Before I introduce our speaker, I'd like to give you a bit of background about CLIA and CLIA's annual law conference. CLIA was incorporated in 1984 and will be celebrating our 40th anniversary next year, so we're quite excited about that. CLIA has held an annual law conference for decades. Each year we feature a different topic. When we first started holding the conference, our target audience was teachers. We expanded the target audience to service providers and the general public. Everyone is welcome, but for lawyers attending, you might find the information pretty basic, especially for practicing family law. Our annual law conference was held in person, usually the last Friday in February. Because of COVID-19, we transitioned to a virtual conference over several days. One positive outcome was that we were able to reach more people, especially outside of Winnipeg. So now a little bit about our presenter. Nina Holatova graduated from law school in 2019 and completed her articling term at Legal Aid in Dauphin, focusing primarily on the area of family law. Following her call to the bar, Nina joined a private firm where she continued to represent clients in a range of family law matters, as well as wills and estates, real estate, and civil litigation. Today, Nina is a lawyer and project coordinator at Community Legal Education Association and delivers webinars across the province on topics such as family law and elder abuse. And one piece of housekeeping before I turn over to Nina, we will hold off questions till the end of the presentation. So, but do please feel free to put them into the chat or into the Q&A, and we'll deal with them at the end of the presentation. I'll let Nina take it away. Thank you very much.
Thank you for that introduction, Mary. Okay, hello everybody, and thank you for joining us today. As Mary said, my name is Nina, and today's webinar topic is changes in family law. So I'm going to be talking about some of the major overhauls that the family legal system has gone through over the last few years in particular. And before we get started, just a little disclaimer that the contents of today's presentation do not constitute legal advice. It's legal information only. That being said, we only have an hour today, so let's go ahead and jump right into the presentation. So as some of you may know, family law has gone through quite a few changes over just the last few years alone. In 2019, we saw the introduction of the new triage and case management model, and this was provincial. Then shortly after that, we saw the Family Law Modernization Act, which was gradually rolled out over the course of a couple of years. And then we had the Divorce Act amendments, which came into effect in 2021. And that's really the only major federal change that we've seen in family law. And then this year in 2023, we have Bill 17, which is the Family Law Act, the Family Support Enforcement Act, and the Interjurisdictional Support Orders Amendment Act. So this is, again, provincial legislation that will be coming into effect probably sometime soon this year. I don't know exactly when that's going to be yet. I don't think we know yet. I don't think we have a date. But as we'll see, the changes that we have here are really meant to catch up to those amendments that we saw a couple of years ago in the Divorce Act. I'm only going to talk about the older changes briefly and provide a little bit of context, and then we'll turn to the new legislation with a focus on the Family Law Act in particular, because that's where most of the major changes lie and the changes that are going to impact parties and lawyers the most. So going back to 2019, this was when I had just started articling. So right after these changes came into effect was when I joined articling. I never got to experience the old system myself, but I've heard that there was a time that you could set a case conference and essentially go to court immediately after filing and serving your petition or your originating document. So the purpose of the old model was to have the case dealt with efficiently, to reduce costs as much as possible, and to encourage parties to try to settle family law issues on their own. So you could file your petition for divorce, and then essentially end up in family court right away to start to deal with some of those issues in front of a judge. However, under the old system, the court was finding that a lot of people were coming to court unprepared at their first case conference, and that this maybe wasn't the most efficient or effective way to handle family matters. So in comes the new FD model, the new family model, and there were a couple of different objectives that were emphasized when this was coming into effect. So the objectives were to ensure that all reasonable efforts are made to resolve or dispose of family cases at the earliest opportunity, to emphasize and ensure that greater judicial resources are available at the front end or the intake stage, to provide a regime of early, active, and meaningful judicial intervention in order to resolve cases at the early stage, and in circumstances where cases cannot be resolved outside of court, to ensure that once cases do reach triage, they flow through the court system with a predictable and finite time period. So the objectives align with the principles of proportionality in family law and the goal of making family proceedings less adversarial. And I think we see some of these same sort of themes and objectives across a lot of the other family law changes as well. So what did some of these other changes look like? So firstly, of course, we have the prerequisites. I won't go into these in detail, but essentially, parties have to comply with this list of requirements depending on which issues are live in their family matter. And it can include things like completing financial disclosure, filing certain documents, completing a parenting program, and just attempting to resolve matters outside of court. Only once those prerequisites are complete, then you can attend before the triage screening coordinator at the Court of King's Bench. So all of those prerequisites that apply to your matter, you have to finish them before you actually proceed to court. If you've done all of your homework and the prerequisites are complete and they've been done properly, then at your triage screening date, you're going to get a date for a triage conference, and that's going to be with a triage conference judge. And if not, if you're missing anything or you didn't do those prerequisites correctly, then they're going to send you back to finish those off, and then you can reapply to come back to triage screening court. Once that's all done, you'll have your first triage conference. And the role of the triage judge is to review all of the issues in dispute, to try to resolve the dispute in a cooperative way. And if the triage judge determines that there are certain matters that can't wait to be decided at the case conference, then they might schedule a prioritized hearing that usually takes place within 30 days. The triage judge then schedules a case conference before another judge to take place within 30 days after the triage conference. Then at that first case conference, that's when you book your trial dates. And trial is usually scheduled about 12 to 15 months out, unless parties settle everything and file settlement documents with the court, then the trial has to go on. You can't just cancel a trial and decide not to go through with it because you don't feel like it anymore. Of course, for certain situations, there were rules introduced that allow you to get into court a little bit sooner to obtain an order. So, for example, the master has the authority to grant a variety of orders sort of related to minor or more administrative matters in family law. So this can be things like determining whether somebody has completed their prerequisites, compelling them to complete their prerequisites if they have not done so, appointing family evaluators, referring parties to mediation, motions for substitutional service. So if you can't track someone down to serve them with documents in person, you might be able to serve them another way, and a bunch of other stuff that the master can grant. We also have the new emergent hearing process. And through this process, a party can make an application to a judge on short notice if there is a chance of immediate risk to a party or a child, removal of a child from Manitoba, or loss or destruction of property. So if a judge decides that they're going to hear the emergent motion, there's going to be a hearing. Usually that can happen within a couple of days of filing those documents to request an emergent hearing in your affidavit and your supporting evidence. And then so you have that hearing, and at that hearing, the judge is actually able to make an order. So that's the new FD model, which really revamped court procedure. And next, we're going to take a look at the Family Law Modernization Act. So this act did a couple of things. It provided a legislative framework for family law arbitration in Manitoba, and it also expanded the powers of the Child Support Service and the Maintenance Enforcement Program, which are now considered arms of the Family Resolution Service. And as you may know, the Family Resolution Service, they offer a broad range of services to people who are going through a family law dispute to help them sort of settle things and deal with certain matters outside of court, and also to guide them through the process. So for example, the child support services powers were expanded to permit them to calculate originating orders of child support and to stop recalculating child support for adult children who are no longer entitled. And then the maintenance enforcement program, their authority was expanded so that they were able to actually stop enforcement of a child support order for an adult child who was no longer entitled to child support. They could also suspend or reduce child support in certain circumstances with appropriate evidence. Whereas before this was brought into effect, a payer of child support was required to bring a court application to achieve the same result if the recipient parent maybe didn't respond or didn't consent to the request to reduce or terminate child support. So this gave us a lot of different ways for maintenance enforcement to be able to intervene directly without the need necessarily for a court application. Then we had some amendments to the Arbitration Act to include family law arbitration. It sets out all of the obligations of lawyers who arbitrate family law disputes and rights of appeal for individuals who undergo family law arbitration and are unhappy with the decision. And it also says that decisions reached by an arbitrator must be consistent with the relevant family law legislation. So all of this was brought into effect. And then that brings us to the Divorce Act amendments. These came into effect in 2021, and they are pretty lengthy. So you're going to want to pay attention to these a little bit more because our new provincial changes that we're going to see coming into effect, they're going to mirror a lot of these Divorce Act changes in a lot of ways. And they're really meant to bring our provincial legislation up to speed with what the federal law is doing and to make sure that those two pieces of the law are congruent with each other. So the major amendments, just going through them briefly, and I'll talk about all of these in a little bit more detail. But the major amendments included changes to language surrounding parenting arrangements. It also included the introduction of a list of factors to determine what is in the best interest of a child. Some new rules regarding relocation and providing notice to the other side when it comes to relocating with or without a child. We also have the introduction of family violence provisions, including a definition of family violence, as well as a list of factors for the court to consider when they are assessing the impact of family violence on the best interest of the child. And lastly, there were provisions introduced that set out some responsibilities for parents and lawyers, and also actually for the court. So that being said, these aren't necessarily the only changes that came into effect, but these are the major ones and the ones that I think affected sort of procedure and practice the most. So we're going to talk about the language and the parenting arrangements under the Divorce Act first. So under the new Divorce Act, the terms custody and access are no longer used. And these are the words that most people in the past have been familiar with when talking about what happens to children after separation or divorce. So instead of using those words custody and access, we now have switched to the terms decision-making responsibility and parenting time. The idea of contact and a contact order is also introduced, and this refers to time with a child involving someone who isn't a parent. So for example, a grandparent or other family member. And the way that it's set up is that if two parents, if they're going through a divorce and there is another party who would like to apply to have contact with the child, like a grandparent or another family member, that can be done under the divorce proceedings as well. And the purpose of these changes was to encourage the parents to focus on the needs of the children. The idea is that child custody and access are some of the most emotionally charged and I suppose heavily contested matters in family law, and they generally take longer and are more difficult to resolve because of course there are children at stake. And so there was suggestion from some academics that the language that was used was contributing to this, because custody has sort of connotations of ownership, and it was thought that this sort of reinforced a winner-loser mentality for the parents. And so the new terminology is really meant to be more child-focused and emphasizes the responsibilities that parents have for their children, rather than, custody as something for the parents to fight over. There has never been a legal presumption that children should equally reside with each parent, although there were some groups and some people that were pushing for this. However, this was ultimately rejected, and instead we saw the introduction of the maximum contact principle, which states that the child should have as much time with each parent as is consistent with the best interest of the child. So this could mean a 50-50 split. It could mean that parenting time is split equally, but again, it depends on the best interest of the child. So maybe you have a situation where one parent has not been a very active parent, or maybe there has been family violence or addictions issues or mental health issues, and maybe a 50-50 split is actually not what's going to be best for the child. But the court is going to look at, okay, what can we do to make sure that the child can spend as much time with each parent as possible, while still maintaining those best interests of the child and doing what is going to be right for them and their well-being. So what does it mean for something to be in the best interests of the child? Well, the Divorce Act gives us a list of criteria to consider. The list is non-exhaustive, meaning that the court can and will consider other relevant criteria outside of these factors. But so the factors that we have are things like they have to take into consideration the child's needs given their age and their stage of development, the nature of the child's relationship with each spouse and other family members like siblings or grandparents, step siblings, and so on. Each parent's willingness to foster the child's relationship with the other parent. So if you have one parent who is really trying to prevent the child from seeing the other parent, from having a healthy relationship with the other parent, that's something that the court takes seriously. The history of care for the child. So who was historically the primary caregiver for the child's views and preferences, if the child is old enough and mature enough to express those. Things like the child's cultural, linguistic, religious, and spiritual upbringing and heritage, plans for the child's care, so the child's future care, the ability of each parent to care for the child, the willingness of the parents to communicate and cooperate with each other, the presence of any family violence, as well as any civil or criminal court proceedings that are relevant to the well-being of the child. So this list overlapped a lot with our existing provincial legislation, the Family Maintenance Act, but there were a lot of differences in the lists of factors as well. So in Bill 17 and in the new legislation, we'll sort of start to see that being brought up to speed with what we see here. Okay, moving on, one of the major changes to the Divorce Act was adding provisions specifically meant to address family violence. For the first time, we have a definitive definition of family violence under the Divorce Act, and it states that family violence is any conduct, whether or not the conduct constitutes a criminal offense, by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or for that of another person. And in the case of a child, the direct or indirect exposure to such conduct. So that's quite a mouthful, quite the wordy definition, but it's important because it sets out that family violence isn't necessarily a criminal offense. It doesn't necessarily have to be physical, and it also doesn't have to be directly against the child. Simply the exposure of the child to that family violence can have an impact on them, and the court is now acknowledging that. Along with this, we also get an additional list of factors related to family violence that the court should take into account when addressing the best interest of the child. So this includes how often the family violence takes place. So how often the family violence takes place, how serious the family violence is, whether coercive and controlling behavior is present, whether the violent person has taken any steps to sort of prevent violence and improve their parenting, as well as a number of other factors. The Divorce Act also gave us a new framework to address changes in residence and relocation. So this includes written notice of changes in residence or relocation to be exchanged between parties, best interest criteria for the court to consider, and also burden of proof in certain situations. So essentially, it tells us what is a relocation. Generally, it means that the parenting time schedule for the child is no longer going to be workable because of the move. A parent who has parenting responsibilities has to inform any parent who, or any person who has parenting time or decision-making responsibility or contact with the child if they intend to move the child's residence. It also spells out that the party's notice has to include things like the new address and contact information and the date of the move in writing. So it sets out very specific guidelines for the timeline under which you have to give notice, as well as the information that you have to provide. Relocation, as I said, has to have a significant impact on the child's relationship with a person who has parenting time, decision-making responsibility, or someone who also has an application before the court for one of these things, or again, has a contact order with a child. So essentially, if someone plans to relocate with or without their child and falls under that category, they have to provide 60 days written notice. And after that, the other party will then have 30 days to object to the relocation if they wish to do so. If there is agreement, or if there's no written objection received within 30 days, or if they obtain a court order allowing the relocation, then the party is going to be allowed to relocate. And the Divorce Act has also added to the factors of best interest of the child test that previously existed. And in the relocation context, a court who is reviewing the issue of relocation is going to have to consider a few different criteria. So these factors include the reasons for the relocation, the impact of the relocation on the child, the amount of time spent with the child by each person who has parenting time now, whether notice was provided, whether there are any orders or agreements that specify a geographic area or prevent any relocations from taking place, the reasonableness of the proposal, and compliance with other family law obligations. So for example, if you have a parent who wants to maybe move for work, they know that they're going to get a significant increase. It's going to vastly improve their ability to financially support their children. The court might say, okay, that seems like a good reason for the relocation. If they're saying, well, I'm gonna, move my child across the country because I have a new boyfriend that I met a couple weeks ago and I really want to go be with him, the court might say, okay, not as fair as the first instance, but really they're going to be looking at all of these factors as a whole. Next, we see some responsibilities for parents and for lawyers as well. So parents have to exercise their responsibilities for their children in a manner that is consistent with the best interest of the child. So all of those things that we went over, they have to protect the children from conflict arising from the proceeding. And they have to try to resolve matters through family dispute resolution as much as possible, as much as is reasonable. In addition, they have to provide complete, accurate, and up-to-date information as required. And they also have to comply with court orders. Again, this is meant to really encourage parties to resolve matters in an amicable way as much as possible, while minimizing the impact of a divorce on any children that are involved. There's also a duty on lawyers to essentially inform clients of these responsibilities and to encourage them to resolve matters outside of court, unless there are circumstances where it would clearly be inappropriate to do so. Okay, so all of that being said, we can now get to the new legislation, which is Bill 17. So I'm not going to go through absolutely everything in the new legislation because there have been quite a few changes. Some instances where maybe just wording was changed, things were shuffled around, different headings were added, and just general reorganization of all of the provisions. So what I'll do is I'll focus on some of the more major changes here. And essentially what this bill does is it repeals the Family Maintenance Act, so our existing piece of legislation that tells us what to do about things like custody and child support and spousal support, and other topics as well. But that is going to be repealed, and it's going to be replaced with two new pieces of legislation, two new acts. So first, we're going to have the Family Law Act, And this is meant to govern the rights and duties of family members. And the second piece of legislation is the Family Support Enforcement Act, which governs, you guessed it, the enforcement of support obligations. So we are told that the new acts are written and organized in a way that makes the law a lot clearer and easier to understand. But really the main thing here is, again, that the new provisions are meant to align Manitoba provincial law more closely with the recent Divorce Act changes, and to sort of bring those two pieces of legislation into harmony, because they do often work together, work side by side in a family proceeding. Lastly, here we have amendments to the Interjurisdictional Support Orders Act. I'll talk about that one briefly, but I won't go into a ton of detail. And there are also various amendments to a number of other pieces of legislation, just to make sure that everything is meshing, that all of the definitions are being updated, and we don't have a bunch of inconsistencies between different pieces of the law. So important to be aware of that, I suppose. So first, let's talk about the Family Law Act. It is split up into parts, and we start off with part one, which is the introductory provisions. And the first thing that we see are some new definitions. It tells us what a contact order is, and this is the first sort of hint that we get of language that we've only seen in the Divorce Act up until now. We get a definition of family violence, and we'll go through some of these in more detail, but our definition of family violence is going to be identical to what we see in the Divorce Act, as well as definitions of decision-making responsibility, parenting responsibilities, parenting order, and parenting time. So again, just giving us that new language and clarifying what it is exactly that it means. There are a couple of other new definitions, but nothing really substantive. And there's nothing here that's super new or surprising. I would say that the biggest introduction here is that definition of family violence. Okay, then we have the duties of the parties to a proceeding, the legal advisors, and the court. So again, this mirrors the Divorce Act in a lot of ways. Parties have to act in a way that strives to minimize conflict, to promote cooperation, and to meet the best interests of the child involved in any dispute. They also have to exercise their parental responsibilities or contact in a manner that is consistent with the best interests of the child. There's, again, this duty to protect children from conflict that arises from the proceeding, to try to resolve through a family dispute resolution process, to provide that complete, accurate, and up-to-date information, and to comply with court orders as well. And of course, we have that certification requirement, and that just means that at the end of petition, for example, you have to make a declaration statement that you understand these duties and responsibilities that you have as a party to a family proceeding. Legal advisors, lawyers, they still have this duty to encourage resolution, again, unless it would be clearly inappropriate to do so. They also have that requirement of certification, again, on that, petition for divorce, or petition for divorce, or perhaps the regular petition for common law separation will be updated to include a certification as well. I'm not sure. And lastly, we have some duties of the court. So these are a little different from the Divorce Act, and it says that the court has to ensure that a proceeding is conducted with minimal delay and formality in a way that minimizes conflict between the parties, promotes cooperation, and also protects parties and children from family violence. If a child might be affected by a proceeding under this act, then a court has to consider the impact of the proceeding on the child. So any family proceeding, the court has to consider the impact on the child and the best interests of the child, and then encourage the parties to also focus on the best interests of the child. So it's always on the court to sort of bring the parties back and, remind them, okay, this is what we're here to focus on. We're focusing on the best interests of the child. Let's minimize conflict, and let's see if we can settle something here. Next, we have part 2 of the Family Law Act, and this one is all about determining parentage. A lot of this is very similar to the way that it was set up before. It continues the existing law for determining a child's legal parents, and it also includes recent amendments to the Family Maintenance Act, respecting assisted reproduction. They do mention the best interests of the child, and they state that the most important consideration for the court is making a declaratory order under this section, that is a declaratory order of parentage, is the best interest of the child. So this is a little bit different from what we saw in section 24.4 of the Family Maintenance Act. And the Family Maintenance Act there stated that the best interest test doesn't apply here unless there's an order made under circumstances where the surrogate does not consent. There is also a section, it's called Division 4. All the parts are broken up into divisions now. So Division 4 talks about declaratory orders made outside of Manitoba. Again, things here have been reworded, they've been shuffled around a little bit. But I'm not going to go into that too much. It's mainly sets out the same things, but again, just sort of edited for clarity. If you are interested, you can definitely pull up the acts and check that part out for yourself. And next, let's talk about the parenting arrangements, guardianship, and relocation portions of the act. So this is part 3. We have the same language changes in part 3 that we saw in the Divorce Act. So custody and access are going to be replaced with parenting time and decision-making responsibility. I know that a lot of lawyers in Manitoba have already started to use the new language when drafting documents and agreements. So this just solidifies that and sort of is going to put it into practice for everyone. And there are also new provisions which allow step parents or other family members who stand in the place of a parent to seek parenting time or decision-making responsibility for a child, rather than having to apply for guardianship. So section 37 sub 1 says the court may make an order respecting parental responsibilities for a child on application by either or both parents, or by a person other than a parent who stands in the place of a parent or intends to stand in the place of a parent, if there is leave of the court and notice of the application is given to the parents. So essentially, someone who is not a parent can apply for that parenting time or decision-making responsibility, but they have to get specific permission from the court first. They have to give notice of that to the parents. And if the court provides leave, then they can proceed to sort of argue their case and say why they think that as a non-parent, they should have those parental responsibilities. Applications for guardianship, the laws for which were previously found in the Child and Family Services Act, have been moved over to this act as well, and that's going to be in section 48. So this is in situations where anybody who is not a parent of the child is applying for guardianship. And just like we saw with the Divorce Act, we have this new concept of a contact order, which grandparents or other family members can apply for under this act. Okay, so again, when making decisions that are related to parenting arrangements or contact or guardianship, the court must consider only the best interests of the child. So now we have section 35 sub 3 of this Family Law Act, and it's going to outline the best interest criteria, which is identical to what we have in the Divorce Act. So those two pieces of legislation are in harmony now in that respect. And I've already talked about those, so I'm not going to go over those, that best interest test, but yeah, it is the same as what we have in the Divorce Act. And moving on, we also have the sections related to family violence. So as I mentioned, our new definition of family violence aligns with what we have in the Divorce Act, and the factors that the court have to take into consideration take into account when considering the impact of any family violence on parenting arrangements are also the same. So those same sorts of factors about what was sort of the nature of the family violence, how frequent was it, was there a pattern of coercive and controlling behavior? Has the parent who perpetrated the family violence, have they taken any steps to sort of improve their parenting abilities? Have they taken a parenting program or attended at therapy or anything like that? So this is all going to be important for the court when they're looking at sort of the impact of the family violence on the family and on the children in particular. When looking at the children's best interests, the court is not allowed to consider any past conduct of the person unless that conduct is somehow relevant to their exercise of parental responsibilities, their responsibilities under a guardianship order, or their contact with a child. So this is pretty broad. I think it leaves a lot up to interpretation for the court, but yeah, the court is going to determine what conduct essentially can be brought into a family law case and whether or not that conduct is relevant to the matter at hand. If it's not, then that conduct cannot be considered. Okay, the next part that we have here is about contact orders. So when it comes to contact orders, we touched on them briefly already a little bit, but we have some provisions that give us a little bit more information. So we are told that the purpose of a contact order is essentially to facilitate relationships between children and their grandparents and other family members when those relationships are in the child's best interests. So that is key here. And also to recognize that in exceptional circumstances, children can benefit from contact with non-family members under a contact order when such contact is in the best interest. So essentially giving us two different circumstances where someone can apply for a contact order. One allows for parents and one allows for non-parents to apply for contact order. So non-family members can apply for a contact order, but again, this is only with leave of the court. They have to get special permission from the court. And under these circumstances, if the court is considering whether to grant a contact order for a non-family member, the court has to be satisfied that there are really exceptional circumstances in play that warrant doing so. So this is really seen as sort of an extraordinary measure for very specific circumstances. Next, we have the sections about relocation. So this is found in sections 49 to 52 of the Family Law Act. And again, this brings us up to speed with the Divorce Act. We have the definition of relocation, the same rules about how notice is to be given. So that includes 60 days notice in writing with certain prescribed information that has to be provided to the other parent. And we also have that same best interests of the child test, which gives us some additional factors to look at when it comes to relocation. And that is exactly the same as what is in the Divorce Act as well. So this makes it really, really simple. All of those best interests of the child factors, whether it has to do with parenting arrangements or family violence or now relocation, our provincial legislation is going to match up with the Divorce Act. So it makes things very straightforward. For smaller moves, that is not a relocation. Again, this is very, very similar to what is in the Divorce Act. Section 55 here sets out the rules regarding giving the other party notice. It doesn't really seem to give us any timelines here. So again, a smaller move, something that wouldn't necessarily affect parenting arrangements. Yeah, so it doesn't seem to give us any timelines for that unless I somehow missed it or skipped over it. But essentially, it seems like you just have to give notice before you move if it's not a major move. And if it is a major move, then it bounces you back to the previous sections related to relocation. Next, we have Part 4. This is all about child and spousal support or common law partner support. And this part continues the existing law respecting support for children, spouses, and common law partners. There's not much that's different here. Former spouses can apply for spousal support under this act, whether they were divorced under the Divorce Act or another law. And also it provides that children can apply for child support for themselves. So that's from section 59 sub 1, and it states that the court can make a child support order on application by a parent or guardian of the child, another person on the child's behalf, or the child themselves. Sections 57 to 62 give us some provisions about child support, the duty of parents to provide support for their children, and also secondary duties to provide support by the spouse or common law partner of a parent while the child is in their care, or a person who stands in the place of a parent. When it comes to, let's see here. So the duty to pay child support continues for a parent or a person in place of a parent, even after a guardian has been appointed. Just touching briefly on the duty of parents to provide support for their children. Many lawyers are aware that generally you're not allowed to contract out of child support because it is seen as the duty of the parents. So for spousal support, it's common for people to enter into, cohabitation agreements or prenuptial agreements or postnup agreements, even saying, okay, we're not going to seek spousal support from one another if we separate. And often during divorce or separation proceedings, people do choose not to proceed with spousal support for various reasons, even if there might be some entitlement. That is not allowed with child support. You can't generally enter into like a separation agreement opting out of child support. So nothing changes here. That being said, I do think we had some new legislation not that long ago that didn't come out of Manitoba, but I believe it was Saskatchewan, which actually did allow parents to contract out of child support under very, very specific circumstances in their separation agreement. But we'll see sort of how the law continues to change and evolve under this area of child support, because that is definitely sort of still a developing and expanding area. Spousal support is covered in sections 63 to 73. No exciting changes there really. So we'll skip over that, but feel free to take a peek at those sections if that interests you. And just a couple of other pieces of housekeeping when it comes to the Family Law Act. Any court order that was made under the Family Maintenance Act, our previous existing current legislation, that is going to continue to be enforced. And any proceedings that have started but have not yet been completed under the Family Maintenance Act are going to be moved over and dealt with under the new act. There are also numerous amendments to other acts to reflect our new terminology and the law. So that can all be found at the end of the Family Law Act. And again, that's just meant to make sure that everything is consistent. And if we're changing definitions or provisions of one act, we want to make sure that all our other provincial legislation matches up. Okay, next we have the Family Support Enforcement Act. So we're just going to go through the last couple of pieces of legislation here pretty quickly. As I said, the Family Support Enforcement Act governs the enforcement of support obligations. So this applies to spousal support, common law partner support, as well as child support, and it replaces Part 6 of the Family Maintenance Act. It carries over the existing law to enforce support orders, and it also puts a couple of new things and a couple of new provisions in place. So a new director is appointed, and the director is given all of the powers and duties that a designated officer would have under existing legislation under the Family Maintenance Act. They've also changed the wording. So a maintenance order is now going to be called a support order. And the process has also been said to be simplified in a number of ways, including when it comes to processing payments, executing warrants for people who fail to appear in court on these enforcement matters, and also on the enforcement of orders from outside of the country, which might conflict with prior support orders. That last one is probably pretty niche. We wouldn't see that pretty often, but nonetheless, the director now has these additional powers. Again, because of these changes, we also see amendments to several other acts to reflect the new terminology and the law. Particularly, they mentioned the Garnishment Act, which is seeing some amendments. And there are a couple more changes, a couple of other things that are being introduced with the Family Support Enforcement Act. So if there is a family arbitration award that conflicts with a support order that is made by the court, the director has the power now to enforce the family arbitration award subject to certain conditions. So the support order has to be made first before the family arbitration support award. Also, the arbitration support award has to include so the support order has to be made first. The recipient and the payor have to be the same. And the most important piece of this is that the arbitration support award has to include terms that the award will be enforceable by the director instead of the terms of the order. The last piece here is that the arbitration award has to be registered with the court in accordance with the Arbitration Act. But essentially, this is a situation where maybe you have a court order. I guess it's possible that, you know, neither party is happy with this court order. They want to go back and get a new one, get family arbitration done, and have new sort of provisions put into place. And if they decide to do this, they have to have a clause in the support order, in the family arbitration support award that is going to say that this takes precedence over the previous court order, and then the director is going to have the power to enforce it. So again, pretty narrow circumstances, but it prevents the people from having to go back to court to then try to enforce that family arbitration support award when it was probably what both people wanted in the first place. Or you know, maybe not, but they wanted to at least enter into the arbitration and agreed to do so. As far as the terms of the arbitration, that's up in the air. Okay, the director can also continue to enforce ongoing child support obligations at the request of the personal representative of the estate of a deceased support recipient. So if somebody was receiving child support or spousal support or common law support and they die, they pass away, then they're the personal representative of that person's estate can seek to enforce ongoing child support obligations, and the director can deal with that. Okay, a couple of new items here. Continued, so they can resume enforcement of support for adult children, even if the child support service hasn't included the adult child in their recalculation. If they find that the adult child is still living with the parents and is a dependent and fits under certain criteria, then the director can resume that enforcement. They can also now enter into a payment plan with a payor respecting arrears. And they can also enforce court costs that have been awarded to a support recipient or support payor. So hopefully these changes are going to make support matters a little bit more straightforward without the need to go to court, make applications, and get court orders for absolutely everything. At least in relatively straightforward matters, the director will, and the maintenance enforcement program will now be able to intervene a little bit more and take care of these support matters, particularly child support, to make things a little bit easier. Okay, last slide here. It looks like we're going to end a little bit early, but I'm just going to touch on the Interjurisdictional Support Orders Amendment Act. Essentially, this just clarifies the way that an interjurisdictional application is processed by the designated authority in the court. So for anyone who doesn't know, these interjurisdictional support order applications, this is usually when the parents live in two different provinces or maybe even in a different country. They can have support put into place and then enforced by the province, by Manitoba, and have that be enforced so that the support will actually be received. They are also adding something that says that people will be able to electronically transmit an application or evidence related to an application or an order. So again, a little bit easier, a little bit more streamlined. People are no longer going to have to file paper documents for everything. It'll speed up the process, hopefully a little bit, make things easier, streamline everything. And that is just about all I've got on the Interjurisdictional Support Orders Amendments Act. We do have a couple of minutes left here, so I guess that gives us enough time for questions. So that being said, thank you again to everyone who joined us today. I'm leaving information about CLIA on the screen. I hope everybody found today's presentation helpful and informative. I know that going through the legislation myself, it was definitely an interesting read. So yeah, if anybody has any questions, go ahead. The legislation is new to me as well, so I'll do my best. Yeah, go ahead.